Greetings. It has been a while. I've been under attack by Facebook as of lately, so figured I'd give you guys this opportunity to review some of the work I am also working on about citizenship. So this is an exhaustive memorandum of law about citizenship because we are looking for a way to terminate our civil legal relationship with the corrupted national government. After all, government is a business that delivers only one product, which is protection, and it has customers called statutory citizens and residents. We thought that there ought to be a simple way to terminate our relationship as a customer and thereby restore our sovereignty and equality in relation to that government. Certainly, if the U.S. Supreme Court calls the act of being a citizen voluntary, then there must be a way to unvolunteer and abandon civil protection without abandoning one's nationality, right? The people of the United States resident within any state are subject to two forms of government, one state and the other national, but there need be no conflict between the two. The powers which one possesses, the other does not. They are established for different purposes and have separate jurisdictions. Together they make one whole and furnish the people of the United States with a complete government, ample for the protection of all their rights at home and abroad. True, it may sometimes happen that a person is amendable to both jurisdictions for one and the same act. Thus, if a marshal of the United States is unlawfully resisted while executing the process of the courts within a state, and the resistance is accompanied by an assault on the officer, the sovereignty of the United States is violated by the resistance, and that of the state by the breach of peace. In the assault, so too, if one passes a counterfeited coin of the United States within a state, it may be an offense against the United States and the state. The United States, because it discredits the coin, and the state because of the fraud upon him to whom it is passed. This does not, however, necessarily imply that the two governments possess powers in common or bring them into conflict with each other. It is the natural consequence of the citizen, 92 U.S. 542-551, which owes allegiance to the two sovereignties and claims protection from both. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties which each exacts for disobedience to its laws. In return, he can demand protection from each within its own jurisdiction. United States versus Cruikshank, 92 U.S. 542, 1875, emphasis added. The above U.S. Supreme Court cite led to many questions in our minds that we sought answers for and documented the answers here, such as, if the Declaration of Independence says that all just powers of government derive only from our consent and we don't consent to anything, then aren't the criminal laws the only thing that can be enforced against non-consenting parties, since they don't require our consent to enforce? Certainly, if we do not want protection or benefits, privileges, and immunities of being a statutory civil citizen domiciled on federal territory, then there ought to be a way to abandon it and the obligation to pay for it, at least temporarily, right? We can envision that little that is more anomalous under modern standards than the forcible imposition of citizenship against the majoritarian will. See ergo United Nations chapters Article 1 through 73 recognizes self-determination of people as a guiding principle and obliging members to take due account of the political aspirations of the peoples inhabiting non-self-governing territories under a member's responsibility. Atlantic Charter, U.S., UK, August 14, 1941, endorsing respect for the right of all people to choose the form of government under which they will live. Woodrow Wilson, President of the United States, 14 points addressed to joint sessions of Congress, January 8, 1918. In determining all questions of sovereignty, the interest of the population concerned must have equal weight with the equitable claims of the government whose title is to be determined. Point 5, see also TUA, T-U-A-U-A, 95-1, F Superior Court 2D at 91. American Samoans take pride in their unique political and culture practices, and they celebrate its history free from conquest of involuntary annexation by foreign powers. To hold the contrary would be to mandate an irregular intrusion into the anatomy of Samoan democratic decision making, an exercise of paternalism, if not overt culture imperialism, offensive to the shared democratic traditions of the United States and modern American Samoa. See King versus Andras, 452 F Superior Court 1115 DDC 1977. The institutions of the present government of America Samoa reflect the democratic traditions. That's TUA, T-U-A-U-A versus U.S. 788 F3D 300, Court of Appeals, District of Columbia, Circuit 2015. 13. Complex questions arise where territorial inhabitants democratically determine either to pursue citizenship or withdraw from union with a state. Such scenarios may implicate the reciprocal associational rights of the state's current citizens or the right to integrity of the sovereign itself. But see Medelve versus Texas, 552 U.S. 491 128 SCT 1346 170 LED 2D 190 2008. If the word permanent in the phrase permanent allegiance is in fact conditioned on our consent and is therefore technically not permanent as revealed in Title 8 U.S.C. subsection 1101A31, can't we revoke it either temporarily or conditionally as long as we specify the conditions in advance of the specific laws we have it for and those we don't? Title 8 U.S.C. subsection 1101 definitions for the purpose of citizenship, A, as used in this chapter, number 31. The term permanent means a relationship of continuing or lasting nature, as distinguished from temporary, but a relationship may be permanent even though it is one that may be dissolved eventually at the instance either of the United States or of the individual in accordance with the law. If the separation of powers does not permit federal civil jurisdiction within states, how could the statutory status of citizens carry any federal obligations whatsoever for those domiciled within a constitutional state and outside of the federal territory? If domicile is what impart the force of law to civil statutes per Federal Rules of Civil Procedure 17, and we don't have a domicile on federal territory, then how could we, in turn, have a civil status under the law of Congress, including that of citizen or resident? Isn't a non-resident, non-person just someone who refuses to be a customer of a specific service offered by a government using the civil statutory code franchise? Why can't I choose to be a non-resident for specific franchises or interactions because I don't consent to procure the product or services? If the national and citizen of the United States at birth under Title 8 U.S.C. subsection 1401 involves two components, being national and citizen, why can't we just abandon the citizen part for specific transactions by withdrawing consent and allegiance for those transactions or relationships? Wouldn't we do that by simply changing our domicile to be outside of a federal territory, since civil status is tied to domicile? Citizen, one who, under the Constitution and the laws of the United States or of a particular state, is a member of a political community owing allegiance and being entitled to the enjoyment of full civil statutory rights, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. U.S. Constitution, 14th Amendment, see citizenship. Citizens are members of a political community who, in their associated capacity, have established or voluntarily submitted themselves to the dominion of a government by giving up their rights for the promotion of their general welfare and the protection of their individual as well as collective rights. Herritt versus City of Seattle, 81 Wash, 2D 48 500, page 2D 101 109, Black's Law Dictionary, 6th edition, page 244. How can the government claim we have an obligation to pay for protection we don't want if it is a maxim of the common law that we may lawfully refuse to accept a benefit? Title 26 CFR subsection 301.7701 through 5 -5, domestic foreign resident and non-resident person. A domestic corporation is one organized or created in the United States, including only the state, and during the periods when not states, the territories of Alaska and Hawaii, and the District of Columbia, or under the law of the United States or any state or territory. A foreign corporation is one which is not domestic. A domestic corporation is a resident corporation even though it does no business and owns no property in the United States. A foreign corporation engaged in trade or business within the United States is referred to in the regulations in this chapter as a resident foreign corporation, and a foreign corporation not engaged in trade or business within the United States as a non-resident foreign corporation. A partnership engaged in trade or business within the United States is referred to in the regulations in this chapter as a resident partnership, and a partnership not engaged in trade or business within the United States as a non-resident partnership, whether a partnership is to be regarded as resident or non-resident, is not determined by the nationality or residence of its members or by the place in which it was created or organized. Amended by TD 8813, Federal Register, February 2nd, 1999, Volume 64, Number 21, pages 4,967 through 4,975. In veto, okay, that's Latin, hold on. No one is obliged to accept a benefit against his consent, but if he does not dissent, he will be considered as assenting, vid assent. That's Digest 50, 1769. I gotta get through the Latin. A man may relinquish for himself and his heirs a right which was introduced for his own benefit. See Bovier's Law Institute, 83. Anyone may renounce a law introduced for his own benefit. To this rule, there are some exceptions. See First Bovier's Institution on Law, 83. Bovier's Maxims of Law, 1856, is the source. If I am not allowed to abandon the civil statutory protection of Caesar and the obligation to pay for it, and I am forced to obey Caesar's social compact and franchise called the Civil Code, a franchise, and am forced to be privileged and a civil subject, isn't there an unconstitutional taking without compensation of public rights attached to the statutory status of citizens if we do not consent to the status? Involuntary servitude. What if I define what they call protection not as a benefit but an injury? Who is the customer here? The customer should be the only one who defines what a benefit is and only has to pay for it if he defines it as a benefit. If Congress can employ money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, ergo benefits, they may take the care of religion into their own hands. They may appoint teachers in every state, county, and parish and pay them out of their public treasury. They may take into their own hands the education of children, establishing in like manner schools throughout the Union. They may assume the provisions of the poor. They may undertake the regulations of all roads other than post roads. In short, everything from the highest object of the state legislation down to the most minute object of policy, of police, would be thrown under the power of Congress. We, the people of Congress, to establish in the latitude contended for, it would subvert the very foundation and transmute the very nature of the limited government established by the people of America. If Congress can do whatever in their discretion can be done by money and will promote the general welfare, the government is no longer a limited one possessing enumerated powers, but an indefinite one subject to particular exceptions. James Madison, House of Representatives, February 7th, 1792, on the cod fishery bill granting bounties. The U.S. government claims to have sovereign immunity that allows it to pick and choose which statutes they consent to be subjected to. See Alden versus Maine, 527 U.S. 706, 1999. Under the concept of equal protection and equal treatment, why doesn't every person, or at least human being, have the same sovereign immunity? If the government is one of the delegated powers, how did they get it without the individual humans who delegated it to them also having it? Why isn't the same government subject to the Foreign Sovereign Immunities Act, Title 28, U.S.C. Chapter 97, and suffer a waiver of sovereign immunity in state courts when it tries to commercially invade a constitutional state against the consent of a specific inhabitant who is protected by the Constitution? Isn't a statutory citizen just a consenting customer of government services? Shouldn't that customer have the same right to not be a customer for specific services, franchises, or titles of code? Isn't the essence of freedom choice and exclusive control over your own private property and what you consent to buy and pay for? Isn't it a conspiracy against rights to punish me by withdrawing all government services all at once if I don't consent to everything, every franchise and every duty arbitrarily imposed against citizens or residents by the government? That's how the current system works. Government refuses to recognize those such as state nationals who are unprivileged and terrorizes them and steals from them because they refuse to waive sovereign immunity and accept the disabilities of being a statutory citizen. What business other than government as a corporation can lawfully force you and punish you for refusing to be a customer for everything they make, or starve to death and go to jail for not doing so? Isn't this an unconstitutional title of nobility? Other businesses and even I aren't allowed to have the same right against the government and are therefore deprived of equal protection and equal treatment under the Constitution instead of statutory law. If the First Amendment allows for freedom for compelled association, if the First Amendment allows for freedom from compelled association, why do I have the same status for every individual interacting with the government? Why can't I, for instance, be all of the following at the same time? A political but not statutory civilian, citizen of the United States under Title VIII, a non-resident for every other title of the U.S. Code because I don't want the benefit or protection of the other titles, a non-resident, non-person for every act of Congress, no domicile on federal territory or within the statutory United States, and therefore immune from federal civil law under Federal Rules of Civil Procedure 17b. A private person only under the common law with a domicile on private land protected by the Constitution but outside the state, which is a federal corporation. Only those who are public officers have a domicile within the statutory state, and only while on official duty pursuant to Title IV U.S.C. subsection 72, when off duty, their domicile shifts to outside the statutory state. If the citizen in Title VIII of the U.S. Code, the same citizen that obligations attached to under Title 26 and 31, could Congress have instead created an office and a franchise with the same name of citizen of the United States under Title 26, imposed duties upon it, and fooled everyone into thinking it is the same citizen as the one in Title VIII? If the Bible says that Christians can't consent to anything Caesar does or have contracts with him, Exodus 23, 32 through 33, Judges 2, 1 through 4, then how could I, as a Christian, lawfully have any discretionary status under Caesar's civil franchise codes, such as statutory citizen or statutory resident? The Bible says, I can't have a kingdom above me. Owe no one anything, including allegiance, except to love one another. For he who loves his neighbor has fulfilled the law. Romans 13, 8, Bible, King James Version. If the Bible says that God bought us for a price and therefore owns us, then by what authority does Caesar claim ownership or the right to extract rent called income tax upon what belongs to God? Where is the separation of church and state in that? Isn't Caesar therefore simply renting out stolen property and laundering money if he charges taxes on the use of property which belongs to God? For you have bought by Christ For you were bought by Christ at a price, his blood. Therefore glorify God in your body and in your spirit, which are God's property. 1 Corinthians 6, 20, Bible King James Version. The answer to the above question appears later in sections 3.6.5. Anyone who can't answer all of the above questions with answers that don't contradict themselves or the rest of the law is lying to you about citizenship, and probably because they convert your property and benefit commercially from the lie. Our research in answering the above very interesting questions reveals that there is a way to terminate our status as a statutory citizen and customer without terminating our nationality, but that is carefully hidden. The result of our search will be of great interest to many. Enjoy. The purpose of this document is to establish with evidence the following facts. That the Constitution and Title VIII of the United States Code is political law that establishes who are members of the political community established by our country and the various levels of membership that currently exist. Number two, those born or naturalized on federal territory are not party to the U.S. Constitution or even mentioned in the Constitution. Hence, political law in Title VIII is required as a substitute for a missing constitution to establish their political status. 3. that the status of a person under political law is regulated only by the following events. 3.1, birth. 3.2, naturalization, Title 8 USC subsection 1421. And 3.3, expatriation, Title 8 USC subsection 1481. The political status is unaffected by civil domicile or changes in civil domicile. Number 5, that all titles of the U.S. Code other than Title 8 that reference citizenship status refer to citizens in their civil rather than political context. Throughout this document, we will refer to the civil context as the statutory context. Number 6, that a failure to distinguish between political and civil context for citizenship terms is the source of much needless confusion in the freedom community. Number 7, the deception is oftentimes caused by abuse, misuse, and purposeful misapplication of words of art, and failing to distinguish the context in which such words are used on government forms and in legal proceedings. Hold on a second, I gotta blow my nose. Things driving me nuts. All right. No, we'll stay there. All right. And to wet my whistle a little bit here. That there are two different jurisdictions and contexts in which the word citizen can be applied, statutory versus constitutional. By statutory, we mean as used in civil federal statutes, and by constitutional, we mean as used in the common law, the U.S. Supreme Court, or the Constitution. 8.1, constitutional citizen is a political status tied to 8.1.1, nationality. 8.1.2, the U.S. Constitution. 8.1.3, political jurisdiction and specific political status. 8.1.4, a national under the law of nations. 8.1.5, memberships in a nation under the law of nations and nothing more. 8.2, statutory citizen is a legal civil status tied to 8.2.1, domicile, somewhere within the nation. 8.2.2, statutory civil law, that law is described as a social compact and private law that only attaches to those with a civil domicile within a specific venue or jurisdiction. 8.2.3, civil legal jurisdiction and legal status. The status acquired is under statutory civil law and is called citizen, inhabitant, or resident. 8.2.4, a specific municipal government among many within a single nation. And 8.3, the difference between these two statuses are explained in the following definition. Nationality, the quality of or character which arises from the fact of a person belonging to a nation or a state. Nationality determines the political status of the individual, especially with reference to allegiance, while domicile determines his civil status. Nationality arises either by birth or by naturalization. See also Naturalization, Black's Law Dictionary, 6th edition, page 1025. That corrupt governments and public servants intend on breaking down the separation of powers between states of the Union and the federal government, purposefully try to exploit legal ignorance of the average American to deceive constitutional citizens through willful abuse of words of art into falsely declaring themselves as statutory citizens on government forms and in legal pleadings. So this is the unfair and deceptive trade practices, okay, that they're violating. This causes a surrender of all constitutional rights and operates to their extreme detriment by creating lifetime and indentured financial servitude and surety in relation to the government. This occurs because a statutory citizen maintains a domicile on federal territory, and the Bill of Rights does not apply on federal territory. Indeed, the practical interpretation put by Congress upon the Constitution has been long continued and uniform to the effect, 182 U.S. 244 279, that the Constitution is applicable to territories acquired by purchase or conquest only when and so far as Congress shall so direct, notwithstanding its duty to guarantee to every state in the Union a republican form of government. Article 4, Section 4, by which we understand, according to the definitions of Webster's, a government in which the supreme power resides in the whole body of the people and is exercised by representatives elected by them. Congress did not hesitate in the original organization of the territories of Louisiana, Florida, the Northwest Territories, and its subdivisions of Ohio, Indiana, Michigan, Illinois, and Wisconsin, and still more recently, in the case of Alaska, to establish a form of government bearing a much greater analogy to a British crown colony than a republican state of America, and to vest the legislative power either in a governor and council or a governor and judges to be appointed by the president. It was not until they had attained a certain population that power was given them to organize a legislature by vote of the people. In all cases, as well as in territories subsequently organized west of the Mississippi, Congress thought it necessary either to extend to Constitution and laws of the United States over them, or to declare that the inhabitants should be entitled to enjoy the right of trial by jury, not a jury trial, or of bail, and of the privilege of the writ of habeas corpus, as well as other privileges of the Bill of Rights. Downs versus Bidwell, 182 U.S. 244, 1901. That once a state national falsely or improperly declares their status as that of a statutory U.S. citizen or citizen of the United States, they are also declaring their effective domicile to be within the District of Columbia pursuant to Title 26 U.S.C. subsection 7701A39 and Title 26 U.S.C. subsection 7408D. It is an effective rather than actual domicile because the civil statutory status of U.S. citizen is an officer in the government by declaring that they have the status, they have volunteered to represent such an officer, such an office. That office, in turn, is domiciled in the place it was created and resides, which is the District of Columbia. They have, in effect, volunteered to work for the national government and be treated as if they are physically present on its land. No matter where their body is physically located, they are a resident agent of the office in the place they live. That Title 8 U.S.C. Subsection 1401 defines a statutory national and citizen of the United States at birth, where United States means the federal zone and excludes states of the Union. Even if they mention the 50 states in the definition of the United States, federal civil law still only attaches to federal territories and those domiciled on federal territory wherever physically situated. Everything else is a foreign state and a foreign sovereign. That the 14th Amendment, Section 1, defines a constitutional citizen of the United States at birth, where United States means states of the Union and excludes the federal zone. That the term citizen of the United States, as used in the 14th Amendment, Section 1 of the Constitution, Section 1 of the Constitution is not equivalent and is mutually exclusive to the statutory national and citizen of the United States at birth defined in Title 8 U.S.C. subsection 1401. Another way of restating this is that you cannot simultaneously be a constitutional citizen of the United States, 14th Amendment, and a statutory citizen of the United States at birth, Title 8 U.S.C. subsection 1401. The first section of the 14th Article, 14th Amendment, to which our attention is more specifically invited, opens with a definition of citizenship. Not only citizenship of the United States, but citizenship of the states. No such definition was previously founded in the Constitution, nor had any attempt been made to define it by an act of Congress. I had been it had been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It had been said by eminent judges that no man was a citizen of the United States except as he was a citizen of one of the states composing the Union. Those, therefore, who had been born and reside always in the District of Columbia or in the territories, though within the United States, were not citizens. Whether this proposition was sound or not had never been judicially decided. Slaughterhouse Case 83 U.S. 16 Wall 3621 LED 394 1873. That the term U.S. citizen as used on federal and state forms means a statutory national and citizen of the United States at birth as defined in Title 8 U.S.C. subsection 1401 and Title 26 CFR subsection 1.1-1C, and excludes constitutional citizens. That a human being born within and domiciled within a state of the Union and not within a federal territory or possession is 15.1 called an American national by the Department of State in Title 8 U.S.C. subsection 1502. Rather than citizens of the United States, we also call these people state nationals in this document. Title 15.2.A, 14th Amendment, Section 1, constitutional citizen of the United States. It is impossible to construe the words subject to the jurisdiction thereof in the opening sentence as less comprehensive than the words within its jurisdiction in the concluding sentence of the same section, or to hold that persons within the jurisdiction of one of the states of the Union are not subject to the jurisdiction of the United States. U.S. versus Wong Kim Ark, 169 U.S. 649 18 S period CT period 456 42 LED 890 1898, emphasis added. Called either an American citizen or a citizen of the United States of America in the early enactments of Congress, see 1 Stat 477 and the following. A national, as defined in Title 8 U.S.C. subsection 1101 A21, but not a statutory citizen as defined in Title 8 U.S.C. subsection 1401 in respect to the federal government. An inhabitant under the law of nations written by Vattel, V-A-T-T-E-L, a free inhabitant under the Articles of Confederation, and non-resident alien if they do business within or are physically present within exclusive jurisdiction on federal territory. Title 26 U.S.C. subsection 873A and B3 identifies national of the United States as non-resident aliens, and these nationals of the United States are non-geographical because allegiance is non-geographical. They include constitutional citizens as well as statutory citizens. Not a national of the United States, defined in Title 8 U.S.C. subsection 1101 A22. Not a person who, though not a citizen of the United States, owes a permanent allegiance to the United States, defined in Title 8 U.S.C. subsection 1101 A22B. Not a national but not citizen of the United States at birth, as defined in Title 8 U.S.C. subsection 1408. Not a statutory national and citizen of the United States at birth pursuant to Title 8 U.S.C. 1401. Referred to in Title 8 U.S.C. subsection 1502 as a person not a naturalized citizen of the United States, and an American national. All statutory U.S. citizens are foreign naturalized by statute to be treated as citizens, but who do not have the privileges and immunities of a constitutional citizen. See sections 1.6.1. Excuse me. That a private human being born within and domiciled within a constitutional state of the Union is 16.1. A statutory non-resident non-person if exclusively private and not a public officer. 16.2. A non-resident alien as defined in Title 26 U.S.C. subsection 7701 B1B if a public officer in the government, they have this status because United States within Title 26 of U.S. Code has a different meaning than that found in Title 8 of the U.S. Code. 16.3, a foreign sovereign and part of a legislatively foreign state with respect to the United States government under the Foreign Sovereign Immunities Act, F.S.I.A. Title 28 U.S.C. Chapter 97. 16.4. An instrumentality of a legislatively but not constitutionally foreign state as a jurist or voter in that foreign state. All jurists and voters in constitutional but not statutory states of the Union are public officers. See, for instance, Title 18 U.S.C. subsection 201A, which admits that jurists are public officers. 16.5. Not a statutory individual, which in fact means a public office in the U.S. government. That the federal government uses the exceptions to the Foreign Sovereign Immunities Act, FSIA, found in Title 28 U.S.C. subsection 1605A2 to turn non-resident aliens into resident aliens as defined in Title 26 U.S.C. subsection 7701B1A. It does this by offering commercial franchises and government benefits to foreign sovereigns outside its jurisdiction and thereby making them residents, in violation of the organic law which forbids alienating rights protected by the Constitution. That government has a financial interest to deceive us about our true citizenship status in order to, 1, encourage and expand the flow of unlawfully collected income tax revenues, commerce. 2, expand its jurisdiction and control over the populace. 3, centralize all control over everyone in the country to what Mark Twain calls the District of Criminals, not the District of Columbia. That the purpose of deliberate government deception about citizenship is to destroy the separation of powers between the state and the federal government that is the foundation of the Constitution of the United States of America, and to destroy the protections of the Foreign Sovereign Immunities Act, FSIA. It does this by 1, using social insurance as a form of commerce that makes Americans into resident aliens of the District of Criminals, District of Columbia, which is what United States is defined as in Title 26 U.S.C. subsection 7701A9 and A10. And 2, misleading Americans into falsely declaring their status on government forms as that of a U.S. citizen, and thereby losing their status as a foreign state under the provisions of Title 28 U.S.C. subsection 1603B3, that the abuse of equivocation to make state constitutional citizens appear equivalent to territorial statutory citizens is the main method of unconstitutionally extending federal jurisdiction into otherwise legislatively foreign states of the Union and imposing what the designer of our three-branch system of government called political law upon those who are otherwise private and immune from ordinary acts of Congress. Okay, and there's actually 4 branches to the government. They always forget we the people. Okay, the Spirit of the Law, Book 26, Section 15, that we should not regulate by the principles of political laws those things which depend on the principles of civil law. As men have given up their natural independence to live under political laws, they have given up the natural community of goods to live under civil laws. By the first, they acquired public liberty. By the second, private property. We should not decide by the laws of public liberty, which, as we have already said, is not only the government of the community, what ought to be decided by the laws concerning private property. It is paralogism, 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 to say that the good of the individual should give way to that of the public. This can never take place except when the government of the community, or In other words, the liberty of the subject is concerned. This does not affect such cases as relate to private property, because the public good consists in everyone's having his property, which was given him by the civil laws, invariably preserved. Cicero maintains that the agrarian laws were unjust because the community was established with no other view than that one might be able to preserve his property. Let us therefore lay down a certain maximum that whenever the public good happens to be the matter in question, it is not for the advantage of the public to deprive an individual of his property, or even to retrench the least part of it by a law or political regulation. In this case, we should follow the rigor of the civil law, which is the palladium of private property. And that reminds me of Atlas Shrugged when he says, "Public be damned." You know, if I'm going to allow this government to take away what I have built and generate it to the public good, and the judge looks at him and says, "Would you have the people of this community know that you're not willing to donate your labor, your hard work and earnings to the benefit of the public good?" And he said, "Public good be damned. Because if I allow you to take my property today, what stops you from tomorrow casting us all into slavery under the guise that it's in the best interest of the public?" And then he said, the judge looked back at him and said, well, sir, what good is being so selfish doing for your community? He says, "There's 1,000 ways that I can articulate that. I've created thousands of jobs. I've created billions in revenue, and all of that done under the private sector," right? So what the government was trying to do was encroach upon the private sector and take from this man under the guise that it was in the best interest of the public good. And he said, "Public good be damned." Okay? Get off your asses and go do something if you want something in this world. Nothing comes fucking for free. Period. End of story. And then at the end of it, in Atlas Shrugged, it was beautiful. They said, "We cannot make a martyr of this man. I'm not going to allow this court to make a martyr of this man. He stands on sound doctrines and principles. We're not going to beat him. If anything, we're going to be the villains in this. The people are not going to receive us taking from this man as justified, and we become the villains, and we're not going to allow it. We're going to dismiss this case." And that's what they did. So go check out Atlas Shrugged. Beautiful, beautiful movie. It was originally written by Ayn Rand. She's a beautiful philosopher, very knowledgeable woman. Get out a thesaurus and a couple dictionaries when you go to read her books, because you're going to need them. Thus, when the public has occasion for the estate of an individual, it ought never to act by the rigor of political law. It is here that the civil law ought to triumph, which, with the eye of a mother, regards every individual as the whole community. If the political magistrate would erect a public edifice or make a new road, he must indemnify those who are injured by it. The public is in this respect like an individual who treats with an individual. It is fully enough that it can oblige a citizen to sell his inheritance, and that it can strip him of this great privilege which he holds from the civil law, the not being forced to alienate his possessions. After the nations which subverted the Roman Empire had abused their very conquest, the spirit of liberty called them back to that of equity. They exercised the most barbarous laws with moderation, and if any one should doubt the truth of this, he need only read Bemerniar's admirable work on jurisprudence, written in the 12th century. Bemerniar's. Beaumanoirs. Admirable work on jurisprudence. written in the 12th century. They mended the highways in his time as we do at present. He says that when a highway could not be repaired, they made a new one as near the old as possible, but indemnified the proprietors at the expense of those who reaped any advantage from the road. They determined at that time by the civil law. In our days, we determine by the laws of politics. The spirit of the law. Charles D. Menquest, 1758, book 26, section 15. What Menquest is implying above is what we have been saying all along, and he said it in 1758, which was even before the Declaration of Independence was written. The purpose of establishing government is exclusively to protect private rights. Private rights are supposed to be protected by the civil law. The civil law, in turn, is based in equity rather than privilege. Thus, when the public has occasion for the estate of an individual, it ought never to act by the rigor of political law. It is here that the civil law ought to triumph, which, with the eyes of a mother, regards every individual as the whole community. Public, our government rights, are protected by the public or political or government. Public, our government rights are protected by the public or political or government law and not the civil law. The first and most important role of government is to prevent the political or government law from being used or especially abused as an excuse to confiscate or jeopardize private property. That if you are a concerned American, you cannot let this fraud continue and must act to remedy this situation immediately by taking some of the action indicated in sections 1.3. Why the content of this pamphlet is extremely important. What you don't know about citizenship can definitely hurt you. There is nothing more important than knowing who you are in relation to the government and being able to defend and explain it in a legal setting. The content of this pamphlet is therefore very important. Some reasons. 1. Those domiciled on federal territory and who are therefore statutory U.S. citizens pursuant to Title 8 U.S.C. subsection 1401 or Title 8 U.S.C. subsection 1101A22A have no constitutional rights. Let me say that again. Those domiciled on federal territories and who are therefore statutory U.S. citizens pursuant to Title 8 U.S.C. subsection 1401 or Title 8 U.S.C. subsection 1101A22A have no constitutional rights. Misunderstanding your citizenship can result in unknowingly surrendering all protections for your constitutional rights. And again, they're not constitutional rights, they're constitutionally protected rights because you actually have unalienable rights, okay? Indeed, the practical interpretation put by Congress upon the Constitution has been long continued and uniform to the effect 182 U.S. 244 279 that the Constitution is applicable to territories acquired by purchase or conquest only when and so far as Congress shall so direct, notwithstanding its duty to guarantee to every state in this union a republican form of government. Article 4, Section 4, by which we understand, according to the definitions of Webster's, a government in which the supreme power resides in the whole body of the people and is exercised by representatives elected by them. Congress did not hesitate in the original organization of the territory of Louisiana, Florida, the Northwest Territories, and its subdivisions of Ohio, Indiana, Michigan, Illinois, and Wisconsin, and still more recently, in the case of Alaska, to establish a form of government bearing a much greater analogy to a British Crown colony than a Republican state of America. And to vest the legislative power either in the governor, and council or a governor and judges to be appointed by the president, it was not until they had attained a certain population that power was given them to organize a legislature by vote of the people. In all these cases, as well as in territories subsequently organized west of the Mississippi, Congress, thought it necessary either to extend the Constitution and laws of the United States over them, or to declare that the inhabitants should be entitled to enjoy the right of trial by jury, of bail, and the privilege of the writ of habeas corpus, as well as other privileges of the Bill of Rights. Downs versus Bidwell, 182 U.S. 244, 1901. Those domiciled on federal territories and who are therefore statutory U.S. citizens pursuant to Title 8 U.S.C. subsection 1401 or Title 8 U.S.C. subsection 1101A 22A are presumed to be guilty and taxpayers until they prove themselves innocent and therefore a non-taxpayer. All right? So essentially what they're articulating here is the fact that through presumption and assumption, by default, you are presumed and assumed to be a United States citizen until you take the proper methods or steps to let these cretins know that you're not part of their bullshit. If anything, you are a preferred stockholder in the United States corporation, and they owe a duty to you. Okay. Unless the defendant can prove he is not a citizen of the United States under Title 8 U.S.C. subsection 1401 and not the Constitution, the IRS has the right to inquire and determine a tax liability. All right. So when you're doing your taxable terminations or your petition to the tax court, it might be very wise to establish your status right out the gate. Okay. Those who are statutory U.S. citizens pursuant to Title 8 U.S.C. subsection 1401 or Title 8 U.S.C. subsection 1101A22A are required to pay income tax on their worldwide earnings connected to the trade or business, public office, franchise, not just those from sources within the statutory United States, as required by Title 26 U.S.C. subsection 911 and Cook versus Tate, 265 U.S. 47, 1924. The United States is currently the only country that taxes its citizens on earnings anywhere in the world. Every other country in the world only taxes its citizens for earnings within their country. The statutory U.S. citizen franchise offers status, therefore, functions effectively as an electronic leash for all those who claim this status and make them a public officer of the U.S. government, wherever they are and whatever other country they claim to be a citizen of. If you decide to try to expatriate and pursue citizenship in another country, other countries have been known to require you, before you leave, to pay all IRS assessments if you claim to be a U.S. citizen, before they will naturalize you. And if you ask them if they do this for other countries, they will say no. They don't care about tax liability of any other country. How's that for slavery? You are owned if you are a statutory U.S. citizen, and who brought us this wonderful legal innovation? None other than the man most responsible for the introduction and the passage of the 16th Amendment, President Howard Taft himself. He also was the only president to serve as a tax collector before becoming president, and the only president who also served as a Chief Justice of the U.S. Supreme Court. Quite a scam, huh? This scam is thoroughly analyzed as we continue. Those who are constitutional and not statutory citizens are not eligible for any kind of licenses, including driver's licenses. All licenses can be offered only to those domiciled on federal territories not protected by the Constitution. Below is an example, and there are lots more where this one came from. State of Virginia, Title 46.2, Motor Vehicle, Chapter 3, Licensure of Drivers, subsection 46.2-321.8, license, permit, and special identification card to be issued only to United States citizens, legal permanent resident aliens, or holders of valid unexpired non-immigrant visas, exceptions, renewal, duplication, or reassurance. A. Notwithstanding any other provision of this title except as provided in subsection G of subsection 46.2.345, the Department shall not issue an original license permit or special identification card to any applicant who has not presented to the Department with the application valid documentary evidence that the applicant is either 1. A citizen of the United States, 2. A legal permanent resident of the United States, or 3. A constitutional resident alien of the United States. The following authorities require all those who are statutory U.S. citizens, Title 8 U.S.C. subsection 1401, or Title 8 U.S.C. subsection 1101A22A, statutory U.S. residents, Title 26 U.S.C. subsection 7701B1A, and U.S. persons, Title 26 U.S.C. subsection 7701A30, all of whom have in common a domicile on federal territory, to incriminate themselves on government forms in violation of the Fifth Amendment by filling out disclosure documenting all their foreign bank accounts. If you don't disclose your foreign bank account on the Treasury Form TDF 90-22.1, then you can be penalized up to $500,000 and subject to time in prison. On the other hand, if you can prove that you are not a statutory U.S. person, then you are not subject to this requirement. Title 31 U.S.C. subsection 5314, records and reports on foreign financial agency transactions, and Treasury Form TDF 90-22.1, report of foreign bank and financial accounts. The problem with citizenship in a nutshell, it is the greatest absurdity to suppose it would be in the power of one or any number of men at the entering into society to renounce their essential natural rights or the means of preserving those rights, when the grand end of civil government, from the very nature of its institution, is for the support, protection, and defense of those very rights, the principle of which are life, liberty, and the pursuit of happiness and property. If men, through fear, fraud, or mistake, should in terms renounce or give up any essential natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation. The right to freedom being the gift of God Almighty, it is not in the power of man to alienate this gift and voluntarily become a slave. Samuel Adams, The Rights of the Colonist, November 20th, 1772. Next, when we return, because we're going to get back into this, it's a pretty lengthy document, but it's very important, and people are struggling trying to understand citizenship and the colorful art of English deceiving them. And when they read the USC codes, they don't necessarily realize that the USC doesn't necessarily apply to you. Being able to get into the definitions of, for example, like Title 42, Title 18, Title 26, Title 27, when you read the definitions and understanding that through the Government Styles Manual, they will specifically tell you what the word citizen means and in what context they're using it. And this is where the mass confusion comes from, is because people aren't looking at the intent of Congress or the intent of legislators when they're creating these documents, because they presume and assume to understand or comprehend what the word citizen is, or what any other word that they commonly use throughout their everyday life means in the legislative bodies or in an act of Congress. And it couldn't be further from the truth. We have to go look at the definitions. We have to comprehend in what context they are using those specific words and what the meaning of those words means to us as free sovereign individuals, part of a union of states that has foreign political sovereign immunity, okay? So with that said, and I've said that to a judge before, I have foreign sovereign political immunity from all your blasphemous bullshit, and you can stick it up your ass. And oh, what'd you say? That's a fact. That's the truth. That's the essence of knowing who you are and being able to tell them to stick it where the sun doesn't shine in a very polite, dignified way, of course. Okay, and call them back in to standing on their oath, protecting your unalienable rights, and making sure that you're not caused harm, damage, and loss through an artificial scheme orchestrated by some corporation under Title 28, 3002 and its subsidiary corporations. So we'll be back. I just need a small break because I've done this before where I go too long, too hard. I'll lose my voice, and it's a disservice to you guys. So just give me a break. Let me have a cigarette, take a moment, and we'll be back.